Normally, and that's become an interesting word nowadays. Normally, we would have had a conference earlier this year, and you would have presented your annual case law update, and that has been denied us until goodness knows when. But there are one or two interesting cases out there that I think that the community should be aware of and may not be aware of. The first one I'd like to look at, Scott, is Rentincome Ltd.
Yeah.
Just to set the context, the Licensing Scotland Act 2005 provides that where a licence has been revoked or suspended, in an appeal against that decision, it's possible to ask the court for what's called interim recall, so that the suspension or revocation is lifted until the appeal has been determined. And with appeals sometimes taking a very long time to come to a conclusion, that's a very valuable protection. But this case, which you're going to tell us about in a moment, is the first, to my knowledge, where a sheriff or a sheriff principal has actually issued a written decision. There was an early Glasgow case involving the Attic Bar, but it wasn't reported except as a note in Scottish licensing law and practice. So Rentincome Ltd against Aberdeen City Licensing Board, Scott. What's interesting about that, and what can we learn from it?
Okay, absolutely. Well, I had the privilege of acting in that case for Rentincome, and indeed, thanks for reminding me about the Attic Bar. That was a case I was involved in before the then Sheriff Principal at Glasgow. And you're right, it's not reported anywhere. Andrew Hunter appeared on the other side. I do remember from that case, the Sheriff Principal describing the picture I painted of the bar in question as resembling something from a John Wayne film, where people were being literally hurled out of doors, and if not onto their horses. You got the idea of the swing doors with people coming and going as fights ensued when the police arrived. So the facts there were very much redolent of a major disturbance going on in licensed premises involving, as I recall, quite a lot of underage drinkers. The situation in Rentincome was a wee bit different. Rentincome Ltd are a company that operate adult entertainment venue in Aberdeen. They've done so, I think, for about 10 years or so from memory. No problems with these premises at all up until the circumstances leading to this particular matter. Now, long story short, the allegation brought by Police Scotland when they sought a closure order was that the two of the stewards in the premises had assaulted a customer to his severe injury, and that could be tracked back. It was sent to the licence holder, Rentincome. Cut to the chase, what we then have is a closure order hearing before the Aberdeen Board, at which the police appeared. The licensing standards officer was present. My clients were not present at the closure order hearing, and the premises were closed. Now, they weren't present because they'd never been asked to attend. It wasn't a question of they'd been asked to go but chose not to. They simply did not go because they weren't asked. Following on from that, at the same time as that closure order decision was made, which was to last roughly 3 months, the board at the same hearing initiated its own premises licence review application. And quelle surprise, when the order under the closure provisions came to an end on the same day, the board convened the actual review hearing, and it duly revoked the licence. Now, that's when I got instructed. A few months after the appeal was lodged, I got involved. I was asked to fiddle about with the pleadings and see what could be done, and identified what I thought were a number of problems with the approach of the board. And these featured in the application for interim recall to show to the Sheriff Miller, as I recall, that Rentincome had a prima facie case for interim recall. In other words, they had a reasonable enough case, and the chances are they may well win. First problem was that it struck me as being unfair that a board should use a closure order hearing to also be the vehicle to initiate an own premises review application. After all, one has a situation where, to use the old test of bars against the British Rural Marketing Board, there's an opportunity for injustice to be afforded. Why do I say that? Well, the police were present when the board made that decision to initiate its own application for review. and they were present in a room which was not public, the hearing was not public, and to apply the Barr's test, who knows what was said, who knows what was done in those circumstances. The board, I say, also compounded its error by having the same members deal with the ultimate review decision as dealt with the closure and as dealt with the initiation for the review. So the board can't even say, well, different members are dealing with this now, so fresh minds are in play. Other problems, I think, that arise from that case, and there are many in my view, is that I could not find a premises licence review application in the papers. The board found their position on what they call a minute of proceedings as being the evidence that such an application, an own board initiative application, was in play. But all that simply did was refer to the fact there was a closure order. Now, it strikes me for there to be a competent review application before a licensing board, even an own initiative application, there must be some statement of why the board has formed the view that a review should be brought, and that has to be linked back to our old friend, the licensing objectives. It simply wasn't there. And that really takes me to the last point, which is this. It seems to me that arguably the rent income case is another illustration of our old friend Lidl, because it strikes me that even if the door stewards were at fault, it doesn't inexorably follow from that the licence holders were culpable and that therefore a licensing objective was engaged. In other words, the board was rather too quick to reach to the conclusion of, because there was a fight, because there was an assault, which did in fact lead to convictions of the stewards in question, therefore that must be laid at the door of the licence holder. So, in short summary, that's what rent income is about in terms of the substance. Sheriff Miller was persuaded after a few hours of argument that this was a substantial case, there was a case to argue, and he was more than persuaded that the balance of convenience supported the recall of the revocation. In particular, he was not at all impressed by the board's argument that the premises, bearing in mind their adult entertainment premises, could remain open on an unlicensed basis pending an appeal. I should add along the way, the sheriff did make a couple of interesting observations. One of the concerns of the board was the failure of the licence holder, in their view at least, to have in place working CCTV and to be part of the radio link system. Now, without going into the details of that too much, what the board seemed to have said is that because this is in our guidance, therefore you ought to have done it. And they seem to have conflated, again, guidance with conditions of the licence, to take us back to the theme at the beginning of following guidance isn't the same as following a condition imposed by law. There's an argument to be had there. But what the sheriff did say was he wondered whether there was a gap in the recall provisions because he couldn't, in recalling the revocation, impose any conditions in the interim to deal with any concerns that might arise in relation to the premises. So I just wonder whether that's a theme that might be picked on by those who are interested in law reform and whether it's something that may find its way into another iteration of our licensing legislation. As you know, at the final disposal of an appeal, the sheriff can impose conditions on a restored licence, but there may well be an anomaly in not being able to impose conditions in the interim.
Yeah, I agree with that. I think that would be a useful facility on all sides. It also strikes me as rather odd that the test is balance of convenience, which I think is more appropriate, which is an appropriate test in relation to interim interdict. What Nicholson had in mind basically was a test as to whether is there a stateable argument here? Is there some prospect of success, no matter where you want to pitch that? The balance can be really just not understood that at all. Scott, thank you so much for that. The last question is the question we've been asking everyone in the series, and it's called the Ice Cold and Alex question. And just to explain that, on a personal level, when we return to normal, and I hope it's not a new normal, I hope it's normal, you are able to leave your local authority area. You can go wherever you want, do whatever you want, and life is back to pre-March 2020, what would you be like to do as a top priority?
Top priority, I need to get back into my saddle. As you know, Jack, I am a keen equestrian. Took it up in middle age. Always been interested in horses since childhood. Never had the opportunity of doing anything about it until I got a bit older. Sadly, Wendy and I had a holiday booked this year. We were going to ride from Lanark down towards Northumbria over the course of a week or so. In May, all that had to hit the deck. And we have, though, managed to ensure that that holiday is reserved for next year. We've not lost our money, thank goodness, which is a minor matter for many people in this pandemic compared to what's going on for so many. But for us, that was quite a blow, as we'd looked forward to this for some time. So, yeah, in terms of what I'm going to be doing in the new normal, apart from grabbing a curry and a chilled lager, consistent with Ice Cold and Alex, at my local restaurants, sitting in as opposed to taking away, I fully intend to take up that holiday and have a week or so riding, I hope, in the sunshine, down through the borders, and reflecting in the saddle over what a year it's been, and hoping that by that stage, life has got back to the new normal, and everyday pleasures that we all take for granted are available to us all. So yeah, that's where I want to be, in the saddle, somewhere south of Lanark, on a sunny day, probably not with a pint in my hand at that point, which would be wrong for a range of reasons, but heading south and hopefully towards a better year.
That sounds great, and let's hope it is really not too long before that ambition comes to pass. Scott, thank you so much for your time today. It's been great, and we hope to see you in the flesh, in real time, with a case law update at some point in 2021. But meantime, again, thank you so much for taking part in our interview series. Thank you. A pleasure.
Truly great to be asked, Jack. As always, great to chat, great to blether, and just have contact at whatever level with another human being in these strange times. And talking about something I love, licensing law.